Sahaj Vidhi www.sahajvidhi.in. Question 1. What are the significant changes introduced by the Constitution, 44th Amendment, Act, 1978 to emergency provisions contained in Part 18 of the Constitution of India? Are they efficacious enough to prevent the possible abuse of power under Article 352 of the Constitution? Elaborate model answer. The Constitution, 44th Amendment, Act, 1978, was a landmark legislative measure enacted primarily to reverse some of the draconian changes introduced by the 42nd Amendment Act, 1976, and to prevent the recurrence of the abuses of power witnessed during the 1975 national emergency. Its main objective was to safeguard the democratic and fundamental rights of citizens by placing stringent checks on the executive's power to declare and continue an emergency. Significant changes to emergency provisions, Part 18(1) grounds for national emergency, Article 352. The most crucial change was the replacement of the vague term "the internal disturbance" with "armed rebellion" as a ground for declaring a national emergency. This was a direct response to the 1975 emergency, which was declared on the ground of internal disturbance without any actual armed uprising. 2. Cabinet's written recommendation. The President can now declare a national emergency only on the written recommendation of the Union Cabinet. Previously, the Prime Minister alone could advise the President, as happened in 1975. This ensures collective responsibility and prevents unilateral action by the Prime Minister. 3. Parliamentary approval. Reduced approval period. The period for parliamentary approval of an emergency proclamation was reduced from 2 months to 1 month. Special majority. The proclamation of emergency and its continuation now require approval by a special majority, i.e. a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting, of both Houses of Parliament, instead of a simple majority. 4. Duration of emergency. An approved proclamation of emergency can now remain in force for only 6 months at a time. For its continuation beyond 6 months, further parliamentary approval by special majority is required. Previously, once approved, it could continue indefinitely. 5. Revocation of emergency. The President can revoke the emergency proclamation at any time. A new provision was added. If the Lok Sabha passes a resolution by a simple majority disapproving the continuation of the emergency, the President must revoke it. This empowers the legislature to terminate an emergency, a power previously exclusive to the executive. 10% or more members of the Lok Sabha can give a written notice to the Speaker or President, if Lok Sabha is not in session, to hold a special sitting to consider a resolution for disapproving the continuation of the emergency. 6. Fundamental rights during emergency. Non-suspension of Articles 20 and 21. The 44th Amendment explicitly states that the right to protection in respect of conviction for offences, Article 20, and the right to life and personal liberty, Article 21, cannot be suspended even during a national emergency. This is a vital safeguard for core human rights. Suspension of Article 19. Article 358, which deals with the suspension of fundamental rights under Article 19, was amended. It now states that Article 19 can only be suspended when the national emergency is declared on the grounds of war or of external aggression, and not on the ground of armed rebellion. Furthermore, laws made during an emergency that violate Article 19 would be valid only for the period of emergency. Efficacy in preventing abuse of power under Article 352. The 44th Amendment Act has significantly strengthened the safeguards against the abuse of emergency powers, making it much more difficult for the executive to declare and perpetuate an emergency arbitrarily. Its efficacy can be assessed as follows: positive impact, narrower grounds. Replacing internal disturbance with armed rebellion has made the grounds for emergency declaration much more specific and less susceptible to subjective interpretation, thereby limiting executive discretion. Enhanced checks and balances. The requirement of a written cabinet recommendation, special majority for parliamentary approval, and the Lok Sabha's power to revoke the emergency have introduced robust legislative and collective executive checks. Protection of core rights. The non-suspension of Articles 20 and 21 ensures that fundamental human rights, such as protection against arbitrary conviction and the right to life, remain inviolable even during an emergency. This is a monumental protection against state overreach. Judicial review. Although not explicitly part of the 44th Amendment, subsequent judicial pronouncements, E.G., Minerva Mills case, S.R. Bommai case, have affirmed that the proclamation of emergency is subject to judicial review, adding another layer of scrutiny. Limitations. Concerns. while armed rebellion is clearer, its interpretation can still be debated in certain situations. However, it is far less ambiguous than internal disturbance. The power to suspend other fundamental rights, except Articles 20 and under Article 359, still exists, which could potentially lead to human rights violations in areas not covered by these two articles. The effectiveness of parliamentary oversight depends on the political will and strength of the opposition. A government with a strong majority might still, through emergency proclamation such 21, push. Conclusion: overall, the 44th Amendment Act, 1978, has been largely efficacious in preventing the possible abuse of power under Article 352. It has transformed the emergency provisions from a tool that could be easily misused by the executive into a measure with significant constitutional and parliamentary safeguards. The changes reflect a mature understanding of democratic governance and a commitment to protecting fundamental rights, ensuring that a situation like the 1975 emergency is unlikely to be repeated. However, eternal vigilance by the judiciary, media, and civil society remains crucial for upholding constitutional principles. Please visit our website www.sahajvidhi.in for more content.